Good morning. I'm Paul Truster, a program planning lawyer with the Department of Continuing Legal Education. I'd like to welcome you all to this morning's program on the commercial court. I'll begin by thanking our faculty, not all of whom are as yet visibly in place, but all of whom certainly have given very generously of their time and talents in preparing for this program and presenting it and preparing the accompanying binder of materials. We're completely dependent on the efforts of volunteer faculty, and we're certainly very grateful to them. Running just a few minutes behind, so with no further ado, I'll say that it gives me great pleasure to introduce this morning's chair, Peter Griffin. His biography and that of the other faculty members is inside the binder. Suffice it to say for the moment that his practice concentrates on commercial litigation. He's with the firm Lenzner, Slatt, Royce, Smith, and Griffin, a member of the Advocate Society, and an active instructor in several forums. Please join me in welcoming Mr. Griffin.
Thanks very much, Paul. Good morning. It's hard to believe in 1995 that the commercial list has only been with us since 1991. It seems to be a rather well-ingrained portion of commercial litigation practice now, and astonishingly so for many practitioners who probably spend more of their time before that court than any other element of the court. With that practice direction and the development of the court has come a fair degree of process, which, depending on the background and approach you bring to litigation, may come more or less easily to one as far as conforming to it. But that process and its development, I think, has brought us today to focus on essentially three elements. The first, and Patricia Jackson is going to deal with, are the more recent developments on the commercial list, matters which I think will be of value to us all as far as the evolution in various areas. The second and coincidental area is the evolution of a new practice direction, which is to be imminently released. The draft of it appears in the material, and I think we'll all find it of some interest at the Appendix A, Section A11. Now that's a heavily stamped draft, and as I understand it, all of us are obliged to execute a confidentiality and non-disclosure form, which we're to fax to the commercial list office by 4 o'clock today. And the fee, which Justice Farley reminds us, so it has to be paid by all. But the Users Committee very kindly agreed to attempt to get this new practice direction into circulation, albeit in draft at this point, for this seminar, and Justice Farley is going to address some comments to it and the general backdrop against which it was prepared. The last area, and which sort of takes in the banner end of this seminar, is the element of trial practice. As part of the new practice direction is a trial requirements memorandum and a development of the process in the trial end of things, which is of interest to all of us and which we're going to focus on with Frank Newbould, Peter Howard, and myself, ending the matter and the seminar with a panel discussion with Justice Farley, who of course has had a long track record with the commercial court, Justice MacPherson, who's trying to recede into the full background but can be seen in the back of the room, who is more recently sitting on the commercial court, myself, and Lyndon Barnes, who's recently joined us here, who has a good deal of experience on the court. I must say that there are many elements of this seminar which probably will proceed more quickly than the posted time. That, I think, will give us some ability to develop a bit of feedback. This is your court and a seminar in which all of us who practice in this court or want to practice in this court have an opportunity to develop some feedback. And I think it's very important as we hit various subjects as we go. I would encourage anyone who has a point or an observation to make to raise it. When we get to the panel discussion, I think it's very important that we have some participation, because a good deal of the panel discussion will direct itself to how things are to operate within the court, how they will operate, what flexibility there may be in various elements. And all of us, I think, have a duty and an obligation to put some feedback into that process. So I would very much welcome some participation. And I'm told that it will not be held against one in appearing in front of the court. I would like also just to take the opportunity to introduce Belinda Burnett, who's sitting about halfway up on the side. Belinda actually runs the commercial court, contrary to popular rumor, and is very helpful in addressing any inquiries and assisting in getting matters ahead. I'm told that she's under strict instructions not to answer any questions that are dealt with in the practice direction. So with no further ado, I wonder if I could call on Patricia Jackson.
I should tell you that there are, in the interests of full, true, and plain disclosure, 3 false premises to the nature of this topic and my assignment to it this morning that you should be aware of before I go any further. The first is that when I was assigned this topic at an organizational meeting, which I did not attend, it was in the expectation, which has proved to be true, that a new practice direction, which has been worked on for some months, would come to fruition in enough time that it could be discussed at this seminar and I could give you the highlights of it. Well, the good news on the one hand is that it is in that stage. Further good news is it would appear that the commercial list is operating so well that although there have been some important refinements to the practice direction, they don't represent fundamental changes in the way the court operates, and with one exception, don't readily lend themselves to the kind of talk that I was to give this morning. And of course, the one exception is the one Peter's just referred to. That's the trial practice memorandum, but that's the one I'm not supposed to talk about because that's going to be dealt with in the rest of the program. So rather than talk about what is new in the strictest sense, I decided what I'd talk about was what's new, what's not so new, but seems sometimes to be not so well known amongst people who practice maybe sometimes or even frequently in the commercial list. I was asked how I could presume to know what is not so well known except by myself. I can tell you what is not so well known by me is quite large, but I'm not going to bore you with that. But I have observed on some occasions in the faces of counsel in matters preceding me or in matters that I was involved in, some expressions of surprise. I also did a little independent and entirely informal survey of members of the commercial list judiciary who I found myself sitting beside or with from time to time, and what I'm going to talk about, perhaps more importantly than my observations, reflects theirs as to some of the important elements of the list that don't seem to be as well known as they might. The second of 3 elements of full, true, and plain disclosure was that when I took this topic on, I did so in the expectation, which was then right, that I had 2 major commercial matters coming up in the list in the 6 weeks between assignment of the topic and my delivery of this speech. Again, perhaps a tribute to the effective operation of the commercial list, they both settled. And instead, I find myself conducting an inquiry into the prison for women, which is an environment that is as foreign to me as I sometimes sense the commercial list is to people who practice in it. But I think the things I've learned about the prison for women are probably not going to be helpful to you. I guess I could point out that one important difference is that I've so far not found the rules of practice for the prison for women. And the important thing to note about the commercial list is its practice direction. It's very detailed, it's very specific, and I think it's pretty clear. It is the rules of the game. And there is an expectation, which is probably not unreasonable, given the amount of effort that's gone into the effective operation of the commercial court, that people who practice in it will be generally familiar with that direction. The third element of disclosure is that notwithstanding that the program says I'm going to talk about this subject for 35 minutes, I have in print back on my desk an agenda that says I'm talking about it for 20 minutes. And I don't propose to fill up the remaining 15 minutes with hot air. So I'll perhaps get us back on schedule in short order. A major motivation for the creation of the commercial list and its maintenance is a desire amongst people who practice in the commercial area for predictability. Predictability as to result, hence the specialization of the matters that comes before the commercial list, and the commercial experience of the judges who sit on it, and predictability as to schedule. The fixed staging of the various components of an action or a proceeding, fixed dates for hearing, and a disposition not to want to have expensive lawyers sitting around with frustrated clients cooling their heels. And that whole objective, I think, there's been an attempt, I think, in large measure successful to embody that in the practice of the court. And that practice is monitored on an ongoing basis by members of the bench and the bar, in part in the Users Committee to which reference has been made. That's a committee that meets regularly and tries to measure whether there is success, particularly with respect to those two objectives, and provides commentary and feedback where it's thought that there isn't. I noted in one of the papers some suggestion that the makeup of this committee was entirely unknown to most people, which is a little counterproductive to the notion that it's to provide feedback. So you'll find at the back of my paper a list of who's on the Users Committee, and you'll find in the new practice direction a kind invitation from my partner Charles Scott to communicate your comments on the practice of the court to him by fax, please, not by telephone, he says. But I think it's fair to say that the monitoring of the Users Committee suggests that there's been some reasonable success in the achievement of two of those objectives. But it's important to know, and this is sort of a mindset element of practice in the commercial list, that the practice in the court assumes and in large measure requires cooperation among counsel in opposing interests to a level beyond what is generally assumed or has been historically assumed in our courts generally. I'll have more to say about that before I close off. Having said it's important, it's equally important in how the court conducts itself and how we conduct ourselves before it to recognize that it's not always there, sometimes for good reasons, sometimes for bad. But in understanding how these general principles flow through the practices of the court, it's probably also important to put in perspective the fact that the objectives of the commercial list, predictability as to result in scheduling, really in no sense should be unique to commercial matters. And indeed, it is quite possible that some of the modifications to practice that we see in the commercial court will extend more generally into general civil litigation practice, perhaps by example and perhaps otherwise. It's perhaps not surprising that the author of the Civil Justice Review report, or one of the major authors, Mr. Justice Blair, has made some suggestions which bear some resemblance to the operation of the commercial list, and it's probably not coincidental that he sits on that court. In the comments that I make, I'm going to assume a certain sort of general knowledge as to how the commercial list operates, namely that in order to be before the commercial court, you have to have satisfied the requirements of paragraph 1 of the practice direction, which sets a list of the various statutes and kinds of matters that come before the court. One observation I might make that you won't find specifically in the practice direction is that there is, as you may know, a basket clause to that provision, which provides for any other, in effect, I haven't got the language in front of me, any other matters that seem appropriate. And my sense, and I think the sense of others on the Users Committee whom I've canvassed, is that what might be appropriate for the commercial list is often a very large basket of things that may have to do with not necessarily the specific proceedings under the specific statutes listed, but that bear some resemblance to those, that require the interpretation of those statutes or the interpretation of a commercial agreement. The one factor that the courts have tended to tell us will be taken into account in deciding to whether to let something on under this discretionary clause is what the existing backlog and caseload in the commercial list at the time the application is made. And I've heard some observations recently that suggest the current load is such that it might be a good time to bring an application under one of those, under the basket clause. I don't mean that the court is not busy, but that there is a disposition at the moment to allow some cases in under that basket clause. The commercial list, as you probably know, assumes a high degree of case management and chambers attendances with the judge who is in charge of your particular matter. And of course, at least for the time being, the commercial list operates only in Toronto, although you'll see in the practice direction, and it is the case, that in certain circumstances cases can be moved to Toronto if it seems appropriate that they be on the commercial list, having regard to the inconvenience of the counsel involved of attending here. Then what is it that still seems to cause surprise, according to my informal survey and observation? Well, one is, although there's a notional idea that the court is a scheduled court, the reality of that takes some time to sink in. There is a fixed commitment to schedules, which are expected to be made on consent with some recognition of the interests of both parties. And that's reflected in a number of requirements in the practice direction, which I've listed in my paper. I don't propose to repeat that list, but two important elements of it are that there is to be a case timetable prepared with the consent of both parties that takes account of how long it's going to take to go through each stage of the procedure, and that's filed with the court at the outset. And any particular attendance, be it by motion or otherwise, is assumed to be an attendance that will be arranged with consent as to the amount of time involved in the matter and when it should appropriately be scheduled. So once you sort of start to live with the reality of that, as the practice direction says, when you schedule matters, you have to make some reasonable allowance for the preliminary steps. And there is a very serious disinclination, much stronger in my view than elsewhere, to allow last-minute adjournments. And there is not only a disinclination, there's a reason for it. The judges, there aren't a lot of judges on the commercial list. It's a scarce and valuable resource. If they're there, it's important that they be employed in motions. And last-minute adjournments has the dubious result of perhaps leaving a judge unemployed at the focus time. And if that happens too often, these judges will be reassigned. That is not something that the commercial list wants. So that means, it's easy to say and hard to do, that you really are required to think about the entire case, what's really in issue and what's not in issue, and have some mutual assessment of that with counsel, with other counsel at the outset. This leads to two very unnatural acts from lawyers. You actually have to substantially focus and prepare the case months or weeks before you're going to argue it or before you're going to conduct the discovery. And you actually have to agree with the other side about how long that's going to take. I don't say this is always possible. I don't say it always happens. But that's the objective, and it's something that it is assumed we are moving towards. Now, one important safety valve for the assurance that this unnatural act, set of unnatural acts will be encouraged and achieved is something that's become quite popular in the commercial list, and that's the 9:30 appointment. If you have a focused dispute with the other side, either about the scheduling of the entire case or the scheduling of the delivery of materials to ensure that the motion proceeds on time, and you can say this is about specific issues, or indeed if you've got any other matter which is concerning the conduct of the proceedings, which requires or would be assisted by a short judicial intervention, you may make, with short or in urgent cases effectively no notice, although some short notice is urged, a 9:30 appointment before one of the judges of the commercial list. The requirements for the 9:30 appointment are discussed in paragraph 24 of the practice direction, and I'm not going to read it to you, but it contemplates that those attendances will be for matters that are urgent, ex parte, consent, or dealing with scheduling, and that they can be dealt with in less than 10 minutes, which tells you a lot about what you should and should not be scheduling at 9:30. It may be appropriate to deliver brief materials with respect to the matter the day before, but that's not required. The emphasis on the 9:30 appointments is a less formal attendance, a focused issue, its resolution, or some direction to the parties to go away, discuss it further, and report back. So this is not the time to launch the argument of a major issue, and it's not the time to ask a judge to absorb a whole volume of new material. Although in an urgent case, it may be the opportunity to ask the judge to schedule that larger matter on short notice, but you should be prepared for the idea that it may be scheduled in a very short order indeed. The commercial list judges have a disposition which, depending on your point of view, is fortunate or not, to say that if it's required, the judicial day does not end at 4:30. The 9:30 attendance then, to be effective, usually means that you want to schedule the attendance before the judge who is handling your matter. And that means, although the practice direction suggests that these take place at 145 Queen, that it's important that you find out where the judge who's handling your matter is sitting, and if indeed he or she is sitting that day. The 9:30 attendance, I think there's a growing consensus, has become one of the most invaluable tools in the commercial list to achieving its effective operation because of its informality, because of its focused nature. The success and the demand for the 9:30 appointments has led to some concern that there are so many of them that the court day is being delayed and starting often after 10, sometimes after 10:30. The result has been a recent discussion in the Users Committee as to whether the appropriate response to that, because it's counterintuitive in terms of the objectives of the commercial list to have a bunch of expensive counsel who thought their matter was starting at 10 o'clock to be waiting for a whole bunch of 9:30s to finish. The discussion was, is the result that we should be cutting back on the 9:30 attendances and just say there are a limited number, or try to find some ways of achieving additional judicial capacity to handle them. I think it's fair to say the result is there's going to be an effort to, where necessary, to schedule 3 judges on a day to hear 9:30s if that's required. But it's important, if this is going to continue to operate and operate effectively, that you remember 2 things. It's a great resolution when it's necessary. You shouldn't be going up there if it's not. It's obviously not just a time to go up and chat with the judge informally about how the case is going. You really have to be at a point that either requires judicial intervention because you need a short order that has to be out that day or something of that sort, or you've come to an issue that you can't work out with the other side and you think a short conversation, direction, or if necessary, order will resolve it. But given the disposition of the court to think that things can be worked out amongst counsel, perhaps more often than sometimes we may think is reasonable, you should assume that what may often happen is that the issue may become more focused and directed, but it won't be resolved by the judge. Rather, you'll be told to go off, discuss it, and report back in short order. Another area that seems still to cause, I don't know if it's surprise, but concern that there's still more room to live up to the expectations of the practice direction, is with respect to materials that are filed with the court. The caseload in the commercial list is heavy, it's paper, and it's very paper intensive. And there are repeated pleas from the judges, you will have seen them in many of the reported cases, and they are made informally, for a distillation of the party's case. One judge put the question this way: if you were I, and this was one of 10 cases that you had on this week, and you didn't know anything about it, and you wanted to produce a reasoned decision in a timely fashion, what would you need to know? It's a simple question. We all know the theory of it. I'm not sure we always ask ourselves that question when we're filing our materials, and there is an ongoing admonition, please, to do so. And in particular, to think long and hard about a tight and focused factum, which is equally applicable outside the commercial list, but the need is obvious. And secondly, to prepare a compendium of the distillation of the essential factual references in the record, the page out of the long document, the page out of the long case properly highlighted, which is dealt with in paragraph 47. Now, the idea is that this document will be a short one, and it usually is, although there's sometimes when the distillation is to take a pile of material that's that high down to a pile of material that's that high. And Mr. Justice Farley may tell me they should, and he may tell you, he probably will, they should never be that high, but we may differ on that. But to give you a sense of what the court often looks for, where it's achievable, that is the compendium in the Rogers-McLean-Hunter takeover battle that was fought, lest you think this is a 9-to-5 court on Sunday, before Mr. Justice Farley. And all that's in it is just one page out of, in the factual portion, tab 1 page out of a whole series of documents that will be referred to in the argument, and under tab 2, 1 page from each of the relevant cases. and highlighted to say, this is what I'm going to take you to. Its shortness and its apparent simple format, of course, understates or belies the enormous effort that goes into the proper preparation of a compendium. To do it fully, you have to prepare the case, prepare the argument, extract the references, try and get the same, some consensus from the other side as to what extracts and references will be coming in that side's argument, and file it early, the practice direction suggests, or at least the day before. Now, that's the objective, and it's one that, although the practice direction doesn't require it, there is a very strong expectation and encouragement in the commercial list that it will happen. That has to be tempered with some recognition that a compromise of those absolutes is sometimes necessary. One thing that it assists in that is the three-ring format. I mean, it does allow for last-minute additions or hands up during the course of the argument. And there may be cases where, either because of time or because of lack of cooperation or just an inability to agree in the interests of clients, where a joint compendium cannot be filed and the only practical solution is a short compendium from each side. Still preferable, obviously, to an undistilled mass of material. On both, you will have heard me talking more than once about the need to cooperate and agree with counsel on the other side, and I will come back to that point. An issue that is relevant to the achievement of cooperation may be another issue that is clearly still not widely known amongst practitioners in the commercial list, and that's the court's attitude to costs. There are I've seen a number of situations in which what happened clearly took some counsel by surprise. A few things to know. Costs in the commercial list, I would have said until this week, or until last week, are always set at the completion of the particular hearing before the court, and then Mr. Justice Farley ordered an assessment in one of our cases. But in virtually all cases, the costs are assessed immediately upon the completion of the motion or the matter. You may be asked before the result, and before you know whether you won or lose, although you may be starting to have some sense, what you will give if you win and what you will give if you lose in costs, and what you expect if you win. Certain sort of disposition to suggest the two sums need to be the same. They don't, but there better be a reason for the difference, and you should have thought about the reason if there is a difference and be prepared to justify it. That tends to suggest that you want to at least think about whether some description of the amount of time and the expert fees that went into the case will push the costs that would otherwise be awarded to a higher level. You want to consider that because obviously if you think it does, you should come armed with some of the relevant information. But you should also know that there are a number of cases in the commercial list where there is a specific direction from the court that in many instances what will be a more appropriate indication of the appropriate level of costs is the magnitude of the matter, the scale of the stakes. Implicit in that is that that has something to do with the amount of money the successful party or the unsuccessful party was prepared to throw at it. And to think accordingly in terms of the matter that you brought before the court. I have included in the paper as Appendix D a highly miscellaneous and highly idiosyncratic survey of costs in recent commercial list matters. There isn't an attempt by any means to be exhaustive or systematic in the costs extracted, although it's probably fair to say that they reflect in at least 2 or 3 instances some of the higher awards of which I am aware, certainly. I prepared the list, or with some assistance prepared the list, because I had the sense myself that some people were surprised to hear that costs were sometimes ordered on a motion in excess of $20,000. I was myself surprised to find that on at least 2 occasions they've been in excess of $200,000. It's obviously important to know what that range is for at least 3 reasons, and they're illustrated in some of the cases. In one, a party who would have had some sense by the time the question, what will you give, what will you get, was being asked, that all was not going well, said, I will give, if unsuccessful, $400. this was, I think, so far out of the ballpark that it had no impact on the ultimate award, which was $25,000. The other situation, which may lead to embarrassment, if nothing more, is the situation also reflected in some of the cases noted there, where you ask for 10 or 15,000 and the court awards 30. You're lucky you got away with it, but you have to explain to your client why you didn't ask for the right number. And even more difficult is the situation where you ask for a certain level of costs and get it with the comment by way of observation that if you'd asked for more, I'd have given that too. So it does become important to have a sense of what these cost orders are, in part, I think, also to encourage a greater level of consistency in what you can expect, because I think it's fair to say there is still, as you will see in those cases and in others if you look at them, a fair range in the costs awards. And that leads me to the last point, which I've been alluding to throughout, the relationship of all of these things to the assumption of cooperation among counsel. Because in my view, so many of these steps and so many of these procedures assume consultation and cooperation, which is not the same as capitulation to the other side's position on the issues. But in my view, the real test of whether the commercial list can succeed and will continue to succeed is the extent to which it can, on the one hand, encourage cooperation among counsel to eliminate unnecessary proceedings, to achieve the appropriate scheduling so that matters are dealt with in a timely way, but also to identify and be able to distinguish in its treatment cases where agreement and cooperation does not occur. And in the paper, I suggested there were two. I think really there are three. There are a number of cases where we know counsel can't agree, either on the issue, on the narrowing of the issue, on the way the case could be scheduled, or on some other process, whether discovery should be modified or something. There are at least three reasons why that might be true, and it's important to treat each of them differently. One is because the failure to agree on the issue or the procedure or whatever doesn't at all represent a failure of cooperation. It represents the lawyer doing what he or she thinks he or she must do to protect his client's interests. And the perception of that, if it's real and reasoned, doesn't have to be one with which everybody would always agree. The second situation, which I refer to in the paper, is where agreement is not possible because one or more counsel, either on the specific instructions or because of a general disposition, refuses to play by the new rules of the commercial list and insists on full-scale battle and or delay at each opportunity. And there's really a third, and that is when not only is one side engaging in trench warfare of this sort, but both sides are. It seems obvious, although it seems obvious that each of those three cases, in my view, should be dealt with differently. The first one is a case where the dispute is a legitimate one, and the role of the commercial list should be to provide a mechanism for its timely resolution before the court. And I think the commercial list does a pretty good job of that, for what it's worth. The second, let me jump to the third. The second, where nobody's adjusted to the new rules and the trench warfare is absolute, the appropriate result, or the appropriate reaction in general terms to that may well be, at least for some period of time, a pox on both your houses, go off and fight somewhere else, or go away and talk till the cows come home. If you can't adjust to the new reality, that's your problem. But the second situation, in my view, is quite different. One side's trying to play by the rules, is genuinely trying to narrow the issues, is genuinely trying to schedule, and the other side is engaged in trench warfare. Now, I think that the 9:30 appointments and other attendances before the court do provide an opportunity for the judge who becomes familiar with the case to see that that is happening, and the costs, particularly the level of costs awarded in this court, and other mechanisms, of course, provide an opportunity to sanction that behavior. And I guess the closing observation I would make is, in my view, there is some distinction made between those three cases, but it is vitally important to the ongoing success of the commercial list that both counsel and the judiciary recognize and treat differently those three situations. Thank you.
Thank you, Patricia. Perhaps I could call now on Mr. Justice Farley.
Sit here, Pete?
Sure.
Good morning. It's nice to see such a good cross-section of people here who are interested in learning more about the commercial list. Let me address to you the most fundamental concern facing the commercial list at the present time. We have a golf day. June the 8th. If any of you are interested in playing golf, socializing, and having a splendid dinner, remember, vote early and vote often, and sign up for the golf tournament. You can pick up copies of the form from the commercial list office from Belinda, or deal directly with Don Short at Faskin's, and his number is 868-3440. Last year was a tremendous success. This year will be even better. Now, I said to Tricia that when she sat down that we can all go home now. She has covered the waterfront extremely well. Let me make some just general observations before I start speaking on what I am supposed to speak on. One of the interesting aspects, and it's a trick question that we dealt with, and that is, who are the members of the Users Committee? Well, that information has always been available, but it was hidden away in the practice direction, and that way we get to see whether or not people have actually read the practice direction. I would say to you that one of the reasons that we took so much care about the practice direction was because we wanted to make matters easier for council and for the parties, and to make certain that everyone was fully aware of the ground rules on which we were operating, and secondly, to invite comment with respect to those ground rules, because we want to improve the operation of the system. That is the reason, interestingly enough, we thought one of the difficulties with the practice directions in the past were that they were hidden away in the advertising section of the pamphlets of the Ontario reports, and likely would not be looked at, and certainly would not be saved. In fact, when we started to review this situation with Chief Justice Callahan, we realized, quite frankly, to the shock of the judiciary, that there were so many practice directions out there floating around that we couldn't determine what the practice directions were and whether or not they were still operative. They covered the whole waterfront, but it was amazing trying to track down practice directions on every particular subject. And hence, that's the reason that we negotiated with the Ontario reports and the Law Society to have the practice direction actually published as part of the reports, so that it would be more obvious and it would be part of the permanent record, and it would be able to be at least saved and identified. And that is, of course, the reason now that you will get all of the practice directions on all the other subjects published as well. Let me make the observation about the cooperation of counsel. I think that you should appreciate that judges understand human nature, and we also understand lawyer nature. Sometimes there's a coincidence. And we do recognize that there may be some difficulty with respect to cooperation in an adversarial setting. And I think that the three scenarios that Trish laid out are perfectly understandable and in most circumstances, pretty obvious. It's tough to hide a complete conflagration under a bushel. Neither side is cooperating. That's unfortunate, and I think, quite frankly, Tricia's got it dead on. That's a pox on both your houses. Go away, get off the list, or at least don't bother us. Go out and fight your war out in the back alley. One aspect of that, though, may be, do the clients actually know what's going on? And you may find that there's a very strong suggestion that you bring the clients in to see whether or not there is a true resolution of the matter that is available. True in the resolution in the sense either on an overall basis or let's get this warfare conducted on some particular reasonable Geneva Convention rules. And of course, if, as and when the clients do come in, we might discuss the question of a settlement conference or a resort to an ADR solution. It is all too often that clients perhaps misspeak themselves when they attend in your office. And that is, we want to sue the blickety-blank off the blickety-blank off the blickety-blank and kill the other side. Quite honestly, I think when you think about it, what the client is so elegantly saying is, I've got a problem, help me solve it. And that solution may be a matter going all the way through a trial resolution, because not every case can be settled. Certainly we recognize that, but we do think that there are other ways of solving matters, that there are other ways of solving the problem, because the problem may not be a completely legal problem. There may be a lot of aspects out there which are quite extra legal, which are not solved. In fact, they're harmed by a legal solution, even for the victor. Let me comment with respect to how I think the profession has shortchanged itself by a slavish adherence to the aspect of charging legal fees. I don't even get into the aspect of collecting those legal fees. Charging on the basis of a multiplicand of an hourly rate times hours docketed will do nothing but get you all into the poorhouse. An early, successful resolution, a tailor-made solution, which takes into account the extra legal aspects, can be tailor-made to take into account, let's say, tax considerations whereby a judicial determination cannot do that, that provides certainty rather than the uncertainty that occurs with matters going on for 1 year, 2 years, 5 years. Yesterday it was 10 years with respect to a matter that had just been transferred onto the commercial list. People want to get on with their lives. You should also want to get on with your lives. Now, on that basis, I think there's a great logic to saying to your client, and the judges should say it as well to the clients, that that resolution is worth more in legal fees than all of the quarterly fees that you charge over the 2 years, over the 5 years, over the 10 years in that particular case, particularly when it goes on to appeal and takes another 4 years. Now, that's logic. I suspect that you will hear a large sucking sound that perhaps Ross Perot talked about when that observation is made. So I think on a practical basis, what you will find is that you will have to forego the possibility of collecting $100,000 in fees for an early resolution case when you don't extend it over the 5-year period, but that you will have so much time available to you that you will be able to do 5 $35,000 early resolution cases because you should charge a very substantial premium for a successful resolution. Whether it's successful, whether you have to pay money, your client has to pay money, may be better result than the ultimate warfare by a judicial determination. That, I don't suggest for a minute that hourly rates and docketed hours are not important, but I think that they are only truly important as internal management tools to see whether or not the firm is in a practice that is profitable. So I do encourage you to charge appropriately. A good result is worth a very substantial fee. I think you sell yourselves short by going in to the counterproductive situation of the multiplicand of the hourly rate times docketed hours. Now, let me talk to you about the trial requirements memorandum, because that is a very important factor. Why is it important? Firstly, and it is contained in my material at B1. Why did we come up with a trial requirements memorandum? Well, first of all, I found myself repeating myself every time we got into the situation of trying to do a preliminary discussion on the mechanics of holding a trial as to what would be helpful. So I thought it would be helpful to put down in a memo that could be distributed both to counsel involved in the case that's under review, but also to counsel generally, what we are generally expecting. It is a guide. Call it a capital G guide. Take from it what you think is appropriate for your particular case. Not every case needs every aspect of that trial requirements memo. But I think if you go through it, you will find that there are substantial elements in the trial requirements memo that are very beneficial to you. Very beneficial to you merely for structuring your case. Let me observe this. Let us assume even the fastest case, something that from start to finish takes 6 months or a year to get on, from statement of claim to trial. That goes before the trial judge. What does the trial judge have? The trial judge has nothing more, under ordinary circumstances, than the pleadings. Now, given the number of times that counsel have come before me and said that they don't understand the other side's pleadings, and there's a reciprocation by the other side, one really wonders how valuable those vague, rambling, sometimes somewhat inflated pleadings are. You, however, as counsel, have been in the case from the very start. And so you know such things, interesting things, as the names of the parties and what the relationship is amongst the parties, and what the issue may be that truly is there. Let's forget about the punitive damages claim. It just slipped in because somebody forgot to delete it on the computer. And you have an idea as to what happened on what particular day. You're able to get in there and start talking at the trial because you know what's happened. On the other hand, there's the judge madly trying to scribble down. And what does the judge, if you were able to look at the judge's notes of a trial, once the judge got them organized, because sometimes matters aren't put in on a logical basis, what would you find? Well, you'd find something that looks strangely like your own notes that you were able to distill after you'd had your meeting or meetings with your client. And strangely enough, it wouldn't consist of 20 pages of somnambulance literature trying to describe a corporate tree relationship. It would be a diagram. So why not, in the best form of advocacy, rather than trying to describe it in words, put in a diagram that describes the corporate relationship? Makes it pretty simple, doesn't it? So that's what we're looking for. We also suggest a cast of characters. Give us the names of the people. Give us what their functions are. What's their relationship? Who's the father of whom, and who's the Charlie's aunt? We talked about the corporate diagrams. Point form chronology. We don't want anything contentious, but just the meeting was held on April the 23rd, 1995. There was a counteroffer on May the 3rd, 1995. No detail, just point form. Then Tricia's talked very well about the form of the compendium. I think that it's absolutely delightful when you go into either a hearing or a trial and you see the document books, and they're that high. And what do you look at when you see those? You'll see that there are about a dozen yellow stickies somewhere in that pile that's that high. Now, the yellow stickies, of course, refer to the single page that's going to be referred to. The only 12 references to the documentation. The rest is all filler. It's 100 pages of a boilerplate document. So why don't you take an extra half hour, photocopy those pages, highlight the extracts from them. Makes it pretty neat, makes it pretty helpful. And it might also save your back from reaching that cervically challenged situation that I have, that I'm cervically cranky. Anyway, I'm much older than you. I mean, we have so much overload. Despite my youthful appearance, I can remember working in a lawyer's office as a student in Guelph, in which you would be reviewing the 7th carbon copy of a typed document. Now let me tell you, the typists made absolutely certain that the lawyers didn't become too wordy. That was even before the days of Snowpeak. Then, of course, I went on to bigger and better things, and I was a summer student at Confederation Life. But I think that that was so far ago that I cannot claim that I had any involvement in the unfortunate demise of Confederation Life. But I do recall it being such an early time that I was in the investment department and I was writing up a recommendation as to a young stock called Xerox. Now maybe if Confederation Life had taken my advice more seriously, they wouldn't have ended up in the ultimate problem that they did. They might have had more surplus. But we do have a proliferation of documentation. It's not stopped by the computer. We have, or by the Xerox machine, or the photocopier, sorry. It certainly isn't being assisted by the computer. It just pours out more and more and more. But take a look at the cases. The cases are decided upon a small number of points. Get to the issue, understand what the issue is, and deal with it effectively. And how do you do that? You do it by persuading the judge, or better still, the other side before you get to the judge, of the rightness of your particular position. And you don't do it by providing that much documentation. You do it by getting down to the issues. Along that line, in narrowing the issues, certainly there is a great deal that even the most adversarial of counsel are able to agree on some of the facts. They might not be able to agree on all of the facts or most of the facts, but they can get rid of the very obvious matters. The sun actually did rise in the east yesterday, and it rose in the east the day before and the day before that. So try not to be too contentious on every particular point. Do admit where the sun rose 3 days ago. Who knows? By getting on to that particular degree of cooperation, you may elicit cooperation in return. Now, let me tell you the one element of the trial requirements memo which is mandatory, and that is as early on as reasonably possible when you are discussing the trial scheduling of the matter. And you don't have to wait until you've exhausted all the opportunity of trying to resolve the case on a consensual basis. You can come in and you can literally talk about trial scheduling as soon as the dispute starts, if you wish to. That is the witness list and the amount of time that it's expected that the cases will take. Why is that important? Well, part of our, I used to say, our social contract with the bar and with clients was that we would give you fixed dates. My friend Bob took that term over, so I now call it our social compact with you, is that we will give you fixed dates. I believe that we have been successful in over 99% of cases in delivering on those fixed dates. And I do say to you, I fully appreciate, I have said it often, that the judging and the lawyering parts of our respective jobs are probably the easier ones. It's scheduling, which is the toughest matter to deal with. But think about it. We give you a fixed date. You can live and die by that fixed date. In fact, I have observed that we, on certain adjournments, that we share the motto of the French Foreign Legion, which is march or die. Give us a good explanation. You'll get your adjournment, but it better be a very good explanation. And I must say that it's unusual that you would find a commercial list judge, even in these days where you have marriages and remarriages and stuff like that, who would think that there are more than a half a dozen grandmothers in your life who unfortunately died. Axiomatically, the date that you start is the day after somebody else finishes. And therefore, the necessity of having a good handle on how long the case is going to take, and yes, we'll make some adjustments. We'll allow a little bit of slippage time. But we have to know, is it truly what is sometimes referred to? You get counsel in and you say, how long is the case going to take? And the one counsel looks at the other, and the other one looks at the other counsel, and they say, it's going to be a 5-day case. And the other counsel says, yeah, that's right. When you get down to examining the number of witnesses that are planned to be called, and you say, well, how long's that person going to be in direct examination? How long can you reasonably estimate in cross-examination if matters go reasonably? Allow some slippage. And all of a sudden you get up to 17.5 days without there even being argument. Now what has that done? I say, okay, the case, the 5-day case starts on May the 29th. It finishes on Friday, June the 2nd. Somebody else has got their case. You have your case that's starting on Monday, June the 5th. But what happens if that 5-day case doesn't finish in 5 days? It finishes sometime the next week, or the week after that, or the week after that. And that isn't fair, even to the people who are abusing the system. Because in order to juggle that, frequently you'll find that the case has to be interrupted and adjourned. And then you come back to it 2 weeks later, or 2 months later, or you have to get involved in written argument, and that becomes very costly. So all I say to you is that the fundamental to the system working is that we have to have the 3 C's operating of cooperation, communication, and common sense, and coming down to what is truly a legitimate time for that trial to take. Because as Trish said, we have negotiated with the Chief Justice and with the Regional Senior Justice for a certain judicial complement so that we can accommodate these cases, we can accommodate them well, we can accommodate them on an emergency basis. We will do anything we can to accommodate counsel and their clients. But if we find that there's a lot of downtime, then we are going to have those judges taken away. And it's going to become more difficult for counsel to try to get a trial date. Now let me refer you to something that Tom Heintzman, the president of the Canadian Bar Association and counsel at McCarthy, sent me a couple of weeks ago. And this is a survey, summary of a survey that was done in England pursuant to Lord Wolfe's review of the reform of civil litigation, not dealing with the commercial court over there. And it's perhaps a little skewed because it was from a sample of the top 1,000 companies, usually in-house counsel at these companies. And some of the comments are quite interesting. They sound reasonably familiar. The quality and independence of judges are aspects of the system to be preserved, but many complain of excessive time, 70%, and cost, 39%. Specifically, the process is archaic. Unlimited time for counsel to present its case is ridiculous. Cross-examination takes too long, and cases drag on much longer than they need to. Counsel is allowed in many cases to drivel on. 60% favor the option of a paper trial instead of oral arguments / evidence. Barriers to taking a case to court mentioned are cost, 92%, management time, 92%, and the time taken to achieve settlement, 85%. 39% feel distanced by the system rather than in control of proceedings. Nearly all have been deterred by the system from pursuing good cases. 66% consider it takes too long for true issues to emerge during pleadings and discovery. One respondent comments, "There is no mechanism for obliging either party to concentrate on what the case is about and no penalty for leaving things to the last minute." Satisfaction is greatest with the trial itself, 69%. The main complaint is the time it takes to get to court, particularly delays in getting a date, which is often changed subsequently. We're not alone in the mess that we are in. You're all very young. You've got a lot of future ahead of you. I think what you should be interested in as professionals is making certain that you have a civil justice system that you can operate in, that you get some particular reward from, a reward of knowing that you've done a good job, the altruistic side, but also one that is truly financially rewarding to you. Let me also show you what I have often referred to. It's a case called Ashmore versus the Corpaloids, 1992, 2 all ER, 486, House of Lords. Here's the case, the whole case, 8 pages. Get a copy of it, put it under your pillow. It's dynamite. It's absolutely gorgeous. Let me just quote one of the comments. It is the duty to cooperate with the court by chronological, brief, and consistent pleadings which define the issues and leave the judge to draw his own conclusions and the merits when he hears the case. It is the duty of counsel to assist the judge by simplification and concentration, and not to advance a multitude of ingenious arguments in the hope that out of 10 bad points, the judge will be capable of fashioning a winner. In nearly all cases, the correct procedure works perfectly well, but there has been a tendency in some cases for legal advisors, pressed by their clients, to make every point conceivable and inconceivable without judgment or discrimination. In Banque Financière de la Cité S.A. versus Westgate Insurance Co., Ltd., I warned against proceedings in which all or some of the litigants indulge in over-elaboration, causing difficulties to judges at all levels in the achievement of a just result. I said that the appellate court should be reluctant to entertain complaints about a judge who controls the conduct of proceedings and limits the time and scope of evidence and argument. I must say to you, I thoroughly enjoy the practice in the commercial list. I think that counsel who practice according to the 3 C's thoroughly enjoy the practice in the commercial list, and I look forward to those people who have not appeared in the list to join the list and to practice in the list. It is not a court that is restricted to only a particular level of case. Anyone can practice in the commercial list if they practice the 3 C's: communication, cooperation, and common sense. And then, of course, there's the 3 B's, as I've set out in my paper. Be prepared, be direct, be successful. The 3 B's. Thank you very much.
Thank you. That just leads me to 2 points. The first is that you may not have taken the direct implication of those comments, but that if you put the Ashmore and Lloyds Corporation cases, the first case in your authorities under tab 1 in every commercial court case, you're guaranteed of a win. The second is that it's now break time, and we'll take about 15 minutes before we come back and get on to the next section.